Ladies and gentlemen, welcome to lawcaseuk.com. Today I'm going to be looking at the 1979 case of the Crown and Sang. In the case, the House of Lords was asked to consider whether a court has a discretion to exclude evidence where that evidence has been obtained in some way improperly. In particular, the allegation in the case of Sang is that the evidence was obtained via the use of an agent provocateur. Now, I've chosen to examine the case not because it has any great current significance, but because it's an important step in the development of the law in relation to improperly obtained evidence, in particular in relation to that area that concerns entrapment, and that's an area that we focus on quite a bit here at Surrey in the Law of Criminal Evidence module. Now, I say that the case doesn't have any great current significance because it's largely been overtaken by events such as Section 78 of the Police and Criminal Evidence Act, and also the development of the common law, which now provides a more appropriate remedy in entrapment cases in the form of stay of proceedings. Now, I don't intend to say any more about those concepts here, but I have dealt with them in more detail in my analysis of the conjoined appeals of Loseley and AG's reference number 3 of 2000, and you can find that analysis also in the evidence section of this website. Now, returning to Sang, in some ways it's simple because all 5 judges agreed that the appeal should be dismissed. In other ways, it's made more complicated because each of them offered their own independent judgment in support of that conclusion. Now, what I want to do is offer a simple but I hope adequate analysis of the case by focusing on 2 aspects. Firstly, the certified question, which of course is always of importance, and secondly, I'm going to place heavy reliance on the judgment of Lord Diplock, the first judgment delivered in the case. But let me begin with the certified question. It's a difficult question for me to read, so I'm going to read it twice, once in a simple sense, and then secondly I'm going to read it completely with an exclusion added back in. I hope that will make more sense once I've read it to you. So firstly, the question is, does a trial judge have a discretion to refuse to allow evidence to be given in any circumstances in which such evidence is relevant and of more than minimal probative value? The full version is, does a trial judge have a discretion to refuse to allow evidence, being evidence other than evidence of admission, to be given in any circumstances in which such evidence is relevant and of more than minimal probative value? Now, the first thing to note about that question is that although the context for it is improperly obtained evidence, that's not mentioned in the question. So the question itself is wider than the context in which it's given. The second thing is that there is this exclusion, and for me a key to understanding the case of Sang is to understand why there is this exclusion and then what is left that the House of Lords are considering. So the court, because of this exclusion, was not asked to consider whether there was a discretion to exclude evidence obtained improperly where that evidence amounted to an admission, or if you like, a confession. So why was that? Why was the court not asked to consider that? Now, quite simply, that was because the law on that point was already well settled and understood. For many years, defendants had been protected by the nemo debit principle, the privilege against self-incrimination, the right to silence, which all meant that if the prosecuting authorities had in any way entrapped or tricked people into making confessions, there was a mechanism of excluding those confessions at trial. So Sang is not concerned about confessions, it's concerned about other stuff. Now, if we begin with Diplock's judgment, the first thing that Lord Diplock does is that he confirms that entrapment is not a defence under English law in 1979, and that remains the case today. So he then asks himself the question, should the discretion be available in entrapment type cases? And he concludes that it shouldn't be, in particular because in the absence of a defence, given that there is a full actus reus a full accompanying mens rea and therefore a complete offence, he thinks it would be wrong to use the discretion to exclude prosecution evidence in these circumstances. And in particular, he said it would be wrong for liability to be avoided by the use of what he termed, I quote, the procedural device of preventing the prosecution from adducing evidence of the commission of the offence. So for him, if it's not a defence, it's wrong to use the discretion to achieve that. It's probably worth highlighting at this stage that what we're dealing with here is not, like confessions, evidence obtained after the commission of the offence, because as Diplock says in that statement, it would be wrong to use discretion to avoid the prosecution from adducing evidence of the commission of the offence. And so we're not dealing with post-commission evidence like confessions, we're dealing with actually evidence of the commission of the offence obtained at the time of the commission of the offence. So that's what makes it different in that respect. So thereby he resolves the narrow contextual question in relation to entrapment evidence. But of course, as I've already stated, the certified question is wider than that. So he needs to address this wider ambit. He recognises that there is a general discretion to exclude evidence, and that applies where the evidence is more prejudicial than probative. And this is an important expression for us who study the law of evidence. And Lord Diplock links that expression to the 1914 case of Christie, incidentally a case that's also of relevance for us because it's a rare example of guilt being inferred from silence, but that's an incidental point made by me. But the important thing for Sang is that they link this discretion to exclude where prejudicial value is more prejudicial than probative, and that's linked to the Christie case of 1914. Now, the question therefore becomes, when can that discretion be used, if not in entrapment cases, apart from confession cases which are not being considered? And he gives examples of bad character evidence and also similar fact evidence. But of course, we will recognise that since 1979, the law has developed in both of those areas. But those are the examples he gives then. But having identified those, he reiterates that this discretion does not extend to evidence on the grounds that it was obtained by improper or unfair means. So he's identified the wider context, and in relation to this, I think it's worth pointing out a case that Lord Scarman refers to, the 1861 case of Leatham, where it says, in effect, it doesn't matter how you get the evidence, even if you steal it, it's still admissible. And so that was the position in 1861, and in terms of our historical analysis in 1979, in some cases that's still how the law reviews or regards improperly obtained evidence. Now you might be saying, what of the principle of fair trial in this particular scenario? And Lord Diplock does consider this, but what I think is interesting is to see how narrow an approach the court takes to fair trial in 1979 compared with the wider way we would consider it now, particularly in light of Article 6 of the ECHR. And as an example of this, Lord Diplock says what the judge at the trial is concerned with is not how the evidence sought to be adduced by the prosecution has been obtained, but with how it is used by the prosecution at trial. And he's reinforced in this by a comment by Lord Scarman in his judgment when he says, what does fair mean in this context? It relates to the process of trial. So it's clear that they are interested in a fair trial, but fair trial really is what goes on in the courtroom, not what goes on in the police investigation, and therefore it is narrower than the way that we might regard fair trial now, where of course the police investigation will be part of the fair trial process. Another thing that Lord Diplock says towards the end of his judgment is that he identifies in this, as he links it to saying that it doesn't matter that evidence is improperly obtained. He says that it's not the judge's function to discipline the police or the prosecution for the way that the evidence is obtained. So that is the state of the law in 1979 from the case of Sang. It can be poetically summed up, I think, from a statement that Lord Fraser makes in the case, in his judgment, and he says, "So when Eve, taxed with having eaten the forbidden fruit, replied, 'The serpent beguiled me,' her excuse was, at most, a plea in mitigation and not a complete defence." So that's Sang. Now, in terms of wider analysis of the position on entrapment and improperly obtained evidence, I suggest you take a look at the case of Loseley for the modern answer. And when you do so, there are a number of areas that you might want to consider when you look at the case. Firstly, ask yourself the question whether entrapment is a defence in modern law. Now, the answer is that it is not. It wasn't in 1979 and it's not today, but that's still good analysis to see that that aspect has not changed. You might also look at what the court's view is in terms of exercising discipline over the police in the year 2000, and Lord Nichols does say something about this in his judgment in Loseley. You might also look at what remedies are now available that mean that Lord Fraser's poetic quote at the end there is no longer an accurate one by the time the Loseley case is decided. And of course, as I mentioned before, that's the enactment of Section 78 and the development of stay of proceedings. You can also compare and contrast the court's approaches in terms of fair trial, and you can ask yourself, what has the impact of Article 6 been in order to encourage this wider approach to be taken? And finally, I would ask you to consider whether you see a moral question being grappled with in the case of Loseley that is largely absent in the case of Sang. And I think there is, and I do mention that in my analysis of Loseley. So that's Sang, and then a little bit of contextual analysis in relation to the later case of Loseley.